My name is Claire Bennett. I am 29 years old. And 2 weeks before my 30th birthday, my own sister stood in an Ashford County courtroom and tried to convince a judge that I was too mentally unstable to control my own money. She spoke softly, like a frightened older sister who had spent years protecting me from myself. She told the court I could not keep a steady job, that I imagined people were stealing from me, and that giving me access to $3.2 million would place me in serious danger. Our mother sat beside her, crying into a tissue, nodding after every accusation. She told the judge I had changed after our father died, and that my sister was the only person responsible enough to manage my inheritance. I did not interrupt. I did not raise my voice or defend myself, even when their attorney described me as paranoid, unstable, and financially reckless. Across the aisle, my sister rested one hand on the folder containing her guardianship petition. She looked at me with the calm confidence of someone who already believed the money was hers. What she did not know was that a sealed file had been delivered to the judge that morning. It contained records she had never seen, documents she thought no longer existed, and one fact about my life that my family had mocked for years without ever bothering to verify. The judge read through several pages, removed her glasses, and stared directly at my sister. "Do you actually know who your sister is?" Our mother stopped crying. My sister opened her mouth, but no words came out. "Before I tell you what happened next, I need to take you back to what was waiting for me on my 30th birthday, and why my own family wanted a judge to believe I was incapable of managing money." Our father, Richard Bennett, built Bennett Medical Logistics from a rented warehouse into one of the most respected medical supply companies in the region. He was not flashy. He drove the same dark sedan for 12 years, packed his own lunch, and remembered the names of warehouse workers he hadn't seen in months. My older sister, Vanessa, was nothing like him. She loved expensive restaurants, private investor dinners, and the feeling of being the most important person in every room. After business school, she moved out west and launched Silverline Ventures, an investment fund focused on wellness technology startups. Our mother, Eleanor, treated every glossy magazine feature about Vanessa as proof that one daughter had inherited our father's ambition, while the other had inherited his habit of hiding behind spreadsheets. That other daughter was me. I worked remotely for a risk advisory firm downtown, analyzing payment records and accounting systems for companies that suspected internal fraud. Because my contracts required confidentiality, I rarely discussed the details of my work. Vanessa described my career to relatives as freelance bookkeeping and told people I spent my days inventing problems inside other people's invoices. I let her believe that because correcting her had never changed anything. For years before the hearing, our father died of a sudden stroke while attending a supplier conference. There was no mystery, no secret confession, no dramatic final warning. What he left behind was a carefully prepared trust. Vanessa received control of the operating company. I was named beneficiary of a separate trust, funded by life insurance and the sale of several personal investments, worth approximately $3.2 million, to be distributed when I turned 30. Our father had explained his reasoning in a letter. Vanessa had already received opportunities through the company. He wanted me to have the freedom to build something of my own. Vanessa called the arrangement unfair, but she could never challenge it publicly without admitting she had already received far more than I had. For a few years, nothing happened. Then Vanessa returned from the coast and took over as Chief Financial Officer of Bennett Medical Logistics. She told everyone Silverline Ventures was expanding into the Midwest. The truth was that several of her investments had failed. 2 health tracking startups had collapsed. A luxury wellness retreat had defaulted on its loans. Investors who once praised her instincts were now demanding their money back. Instead of admitting defeat, Vanessa began moving money through 3 consulting companies registered out west. The companies submitted invoices to Bennett Medical Logistics for strategy, vendor development, and market analysis. In reality, they provided almost nothing. Money left our father's business, passed through those shell companies, and flowed back into accounts connected to Silverline Ventures. By the time the company prepared for its annual audit, the gap was close to $1.8 million. Vanessa needed cash before the auditors reviewed the vendor files. My trust was the easiest target she could see. 9 months before my birthday, the bank administering the trust received an amendment that appeared to give Vanessa authority to manage my inheritance if I became mentally incapable. The bank refused it outright. The signature looked copied. The dates didn't match their records. There was no certificate from the electronic signing platform named in the document. Instead of backing off, Vanessa changed tactics. She began asking questions about my health. Had I seen a therapist after Dad died? Was I still taking anything for anxiety? Why had I changed consulting assignments twice in 1 year? Did I ever feel like people were watching me? At first, I thought she was trying to rebuild our relationship. Our mother joined those conversations too, and encouraged me to be honest. So I was. I told them I'd had panic attacks after Dad's death. I told them therapy had helped. I admitted that working in fraud investigations sometimes made me suspicious of patterns other people ignored. Every honest answer became a sentence they could later strip of context. Vanessa told relatives I was obsessed with hidden crimes. She told family friends I couldn't hold a job. She described my quiet apartment in Ridgewood as evidence that I was isolating myself. Our mother backed her, because Vanessa paid the property taxes, insurance, and maintenance on the large house Eleanor lived in. If Vanessa lost the company, our mother believed she'd lose everything too. Looking back, I can trace the exact moment the tone of those conversations shifted. It was during a family dinner, roughly a year before the petition, when Vanessa asked, almost casually over dessert, whether I'd ever told a doctor that I felt targeted by people close to me. I remember laughing it off at the time, assuming she was making an awkward joke about my job. I didn't realize she was testing a phrase, watching how I responded, deciding whether it could be reused later in a sworn document. She was patient about it. She never pushed too hard in any single conversation. She would ask one pointed question, let it sit, and return to it weeks later dressed differently. Sometimes as concern, sometimes as a joke, sometimes as something she claimed our father had once said about me. Each version was designed to be repeated to someone else, without me in the room to correct it. I still didn't understand how far they were willing to go, until 6 weeks before my birthday, when a process server handed me a petition asking the court to declare me disabled and appoint my sister as guardian of my estate. They hadn't been checking on my health. They'd been building a case. The petition arrived at 8:15 on a Monday morning, 10 minutes before I was supposed to lead a video call with a hospital network client. It described me as unemployed, emotionally unstable, financially reckless, and consumed by delusions about family members stealing money. Attached to it was a psychological evaluation written by a Dr. Marcus Hale. I had met him once, through a video call our mother described as a family wellness consultation. The session lasted 52 minutes. He asked almost nothing about my income, my bills, my work responsibilities, or the fact that I had lived independently for 11 years. Instead, he kept circling back to whether I distrusted Vanessa and whether I believed she was hiding financial information. At the time, I thought he was helping us communicate. In his report, he described my answers as possible persistent delusional thinking and suggested that receiving a large inheritance could place me at risk of exploitation or impulsive behavior. The court didn't hand Vanessa control immediately. It did, however, issue a temporary order freezing the trust until the hearing was complete. My salary account stayed open, but the damage started almost immediately. Vanessa sent copies of the petition to relatives who forwarded it further. Someone contacted one of my clients and claimed I was under investigation for mental incompetence. The client suspended my contract while legal reviewed the situation. I had enough savings to survive for a while, but legal fees, expert costs, and lost income could drain that quickly. I moved temporarily into a friend's guest room in Fairview, because Vanessa had started showing up outside my apartment unannounced, knocking, waiting for me to refuse, then texting our mother that I was shutting out the family. Every reaction I had was being engineered into evidence. That's when I hired Rachel Stern. Rachel specialized in contested trusts, fiduciary abuse, and adult guardianship cases. We'd met years earlier when my firm assisted one of her clients in a corporate embezzlement dispute. She didn't promise me an easy win. She laid the petition on her desk and told me Vanessa had built a powerful emotional story, a grieving younger sister who'd become suspicious and withdrawn, a concerned older sister trying to protect her, a frightened mother who agreed, a doctor who backed them up. Rachel said we couldn't beat that story by being more emotional than they were. We had to replace it with verifiable facts. First, we examined the trust amendment. A digital forensics specialist pulled the file metadata and found the document had been created 3 months after our father's death. The listed author wasn't his estate attorney. It was a user account tied to Vanessa's former West Coast office. An earlier draft of the file had been saved under the name Claire, Control Draft. The signature image had been lifted from an old vendor contract our father had signed years earlier, resized and pasted in. The file claimed to have been completed through an e-signature service, but there was no audit certificate or transaction record to support it. Second, we traced the money. Rachel subpoenaed records connected to the companies that had been invoicing Bennett Medical Logistics. All 3 used the same private mailbox address. Their phone numbers forwarded to the same answering service. Payments moved from the family company into those shell businesses, then into an account controlled by Silverline Ventures, often split into amounts just under internal review thresholds. Together, they added up to the $1.8 million shortage Vanessa was trying to hide. Third, we examined Dr. Hale's report. The invoice for his evaluation hadn't been paid by our mother, as Vanessa had claimed. It had been paid by one of the shell consulting companies. The file properties showed his first draft had been created before he ever interviewed me. An email from Vanessa's assistant had asked him to include the phrase, persistent delusional thinking, because it would support emergency financial protection. He had reached his conclusion before asking me a single question. The most important witness was Daniel Kim, the former controller of Bennett Medical Logistics. Daniel had worked beside our father for 17 years. He'd noticed the consulting invoices and asked Vanessa for contracts proving the services were real. She accused him of resisting modernization and fired him 2 weeks later. He'd kept copies of the approval logs, believing they'd eventually matter in an audit. Those logs showed Vanessa had personally approved every suspicious payment. Then our mother made a mistake Vanessa could never explain away. She called me late one evening while I was still staying in Fairview. I didn't answer. Rachel had told me to keep all communication in writing. My mother left a voicemail. She begged me to stop fighting the guardianship. She said Vanessa only needed temporary control of the trust until the audit was over. She said if I refused, the company could collapse and the house could be taken. Then she whispered that once the missing money was replaced, everything could go back to normal. I listened to that message 3 times. Until then, I had wanted to believe my mother was only repeating lies she didn't understand. The voicemail proved she knew this was about the money. What I still didn't know was whether Vanessa had told her the whole truth, or just enough to make her afraid. By the morning of the hearing, Vanessa had transformed herself into the picture of a patient, exhausted older sister, conservative navy dress, no visible jewelry except our father's old watch, almost no makeup. She sat close to our mother, one hand resting over hers whenever the room went quiet. Her attorney, Nathan Cross, opened by saying the case wasn't about punishment, money, or family conflict. It was about protection. He described me as a talented but troubled woman whose condition had worsened after our father's death, unable to distinguish professional concerns from personal suspicion, moving between jobs, withdrawing from friends, accusing my sister of fraud, refusing help from people who loved me. He never mentioned that my jobs were confidential consulting assignments. He never mentioned that I paid my own rent, taxes, insurance, and student loans. He never mentioned that the financial irregularities I'd reported were backed by bank records. Vanessa testified first. Her voice trembled at exactly the right moments. She said she didn't want my inheritance and would gladly place it under professional management. She claimed the guardianship was necessary because I'd become vulnerable to scammers and imaginary threats. When Rachel asked whether Vanessa had submitted a trust amendment naming herself as my financial advisor, she said she believed our father had prepared it before he died. When Rachel asked who had sent the file to the bank, Vanessa said an assistant handled estate correspondence. She couldn't remember which one. Our mother testified next. She cried before Nathan finished his first question. She told the judge I'd changed after Dad died, that I'd stopped attending family dinners and become obsessed with the idea that Vanessa was stealing. That part was technically true. I'd stopped attending dinners after Vanessa began asking detailed questions about my therapy sessions and the trust's distribution date. My mother said Vanessa had kept the family together, supported her financially, and tried everything to help me. She called signing the affidavit the hardest decision of her life. Rachel asked if I'd ever missed a mortgage payment. I didn't have a mortgage. She asked if I'd ever been evicted, declared bankruptcy, lost money gambling, or transferred funds to strangers. The answer to every question was no. Then Rachel asked whether our mother depended on Vanessa to cover the expenses on her house. Nathan objected. The judge allowed it. My mother admitted that she did. Dr. Hale followed. He spoke confidently about anxiety, fixed beliefs, impaired judgment, and the risks of sudden wealth. He pointed to my suspicion that Vanessa had moved company money as evidence that I interpreted ordinary events as personal threats. Rachel asked how long he had evaluated me. 52 minutes. Had he reviewed my bank statements?
No.
Tax returns?
No.
Employment records?
No.
Medical history from my actual treating therapist?
No.
Had he spoken to anyone in my company? He said confidentiality prevented it, though he'd never actually asked my permission. Did he know I managed complex fraud investigations for corporate clients? He said he'd been told I did occasional bookkeeping work. Rachel let that answer hang in the air. The court-appointed evaluator presented her own report next. She'd visited my apartment, reviewed my expenses, spoken with my employer, and tested my understanding of the trust. She found no evidence I was unable to manage money or make personal decisions. I was anxious about the case, she noted, but anxiety during litigation wasn't proof of disability. Vanessa's expression tightened. Nathan argued the evaluator hadn't addressed my alleged delusions about the family company and that the court still needed to consider whether my intelligence was hiding a serious condition. For a few minutes, it looked like the case might turn into a battle of competing experts. Then Vanessa leaned toward our mother and wrote something on a legal pad. I caught the words, Silvaline and transfer schedule. She was already planning what to do with the money. Rachel saw it too. She closed her folder without another question. The judge requested the sealed materials delivered by my employer and the trust company. A clerk carried the file to the bench. Vanessa watched with mild curiosity. Nathan looked confused. He'd only received a summary under the protective order. The judge read silently for nearly 3 minutes. No one moved. Then she took off her glasses and looked directly at my sister. Vanessa straightened, expecting to be asked whether she was prepared to serve as guardian. Instead, the judge asked the question that shattered the identity my family had spent a year building for me. Ms. Bennett, the judge said, do you actually know who your sister is or what she does for a living? Vanessa gave a small, uncertain laugh. She worked irregular online jobs. She exaggerated her responsibilities for years. The judge asked me to stand and state my full name, age, employer, and occupation for the record. I rose slowly. My name is Claire Bennett. I am 29 years old. I am a lead fraud data analyst for Sterling Risk Advisory, and I am a certified fraud examiner. Vanessa stared at me like I'd started speaking another language. I explained that my work involved tracing fraudulent payments, reconstructing altered accounting records, identifying shell vendors, and preparing findings for attorneys, insurers, and regulators. I'd worked continuously for the same firm for 5 years. The job instability Vanessa described to relatives was actually separate client assignments. My income had increased every year. I had never been fired, disciplined, or found incapable of handling confidential financial information. The sealed file contained my employment verification, tax records, performance reviews, and a declaration from my managing director. It also confirmed I'd been assisting outside counsel in a confidential investigation involving a network of vendor payments. I had no badge, no secret government identity, no dramatic undercover assignment. I was simply very good at finding where money went after someone tried to hide it. The judge told Vanessa that the person she described as financially incompetent was professionally responsible for analyzing transactions worth hundreds of millions of dollars. Vanessa recovered fast. "Intelligence doesn't prevent mental illness," she snapped, accusing me of using my job to feed obsessive suspicions. The judge agreed that a career alone didn't settle the case. Then she opened a second folder and held up the trust amendment Vanessa had submitted to the bank. "If your sister invented this problem," the judge asked, "why does this document, bearing your father's signature, have a creation date 3 months after his death?" Nathan turned toward Vanessa so sharply his chair scraped the floor. He told her not to answer until they'd spoken privately. Our mother stopped crying. All the color left her face. Vanessa claimed she'd never seen the metadata, that an estate assistant had prepared the file. The judge asked for the assistant's name. Vanessa couldn't provide one. The judge asked why an earlier draft had been saved under the title Claire Control Draft on an account linked to Vanessa's former office. For the first time all day, Vanessa had no story ready. Nathan requested a recess. The judge granted 15 minutes, but ordered everyone to remain on the floor. In the hallway, Nathan pulled Vanessa aside and spoke to her in a low, furious voice. Our mother looked at me like she was seeing a stranger. She asked why I'd never told her what I really did. "You never asked," I said. "You believed her version because it was easier." Rachel stepped beside me and warned that the forged trust document was only the beginning. Proving it was false would defeat the guardianship. Proving why Vanessa created it would expose everything else. When the courtroom doors reopened, Vanessa's confidence was gone. What was waiting inside was far worse than she understood. Rachel began with the digital forensics specialist. He explained that every electronic file carries hidden information about when it was created, who edited it, and what software was used. The trust amendment had been created 96 days after our father's death. The author field matched a user account assigned to Vanessa. The signature image had been lifted from an old vendor contract and inserted into the new document. The file had been edited repeatedly from an internet address tied to her former office. Nathan tried suggesting another employee could have used her account. The specialist produced a device log showing the final version had been approved from Vanessa's personal laptop using biometric authentication. Vanessa whispered something to Nathan. He didn't look at her. Daniel Kim testified next, describing his 17 years as controller and his responsibility for reviewing large vendor payments. The 3 shell consulting firms, he said, had no project files, no work products, no identifiable employees. When he questioned the invoices, Vanessa told him to approve them as executive expenses. He refused. 2 weeks later, she fired him. He presented approval logs showing Vanessa had personally authorized every transfer, along with an email in which she'd written that Claire's trust would fix the gap before the annual review. Nathan argued the phrase could refer to a legitimate investment opportunity. Daniel replied that company money couldn't legally be replaced with a private beneficiary's trust unless that beneficiary voluntarily invested it. I had never agreed to invest a single dollar. Rachel then displayed a full timeline, money leaving Bennett Medical Logistics, passing through the shell companies, and returning to Silvaline Ventures. Some paid investor withdrawals. Some covered the lease on Vanessa's residence out west. Some paid for a luxury vehicle registered through one of the shells. Total, $1.8 million. Vanessa called the transfers temporary intercompany loans. There were no loan agreements, no repayment schedules, no board approvals, no disclosures to minority shareholders. Dr. Hale was next. Rachel showed him the invoice for his evaluation. He confirmed his standard fee for a single assessment was far lower than the $18,000 charged. The payment had come from one of the same shell companies in Daniel's records. He claimed not to know who controlled it. Rachel displayed an email from Vanessa's assistant thanking him for helping protect the family assets. Attached was a draft report created 2 days before he ever interviewed me, already containing the phrase persistent delusional thinking. Rachel asked how he'd reached a diagnostic conclusion before speaking to me. He called the draft only a template. She asked why the template already included my name, my father's death, my inheritance amount, and an accusation that I imagined financial fraud. His answers grew slower. The judge asked whether he disclosed the payment arrangement to me or to the court-appointed evaluator. He admitted he hadn't. When Rachel asked whether Vanessa had requested a conclusion supporting guardianship, Nathan objected, but Dr. Hale answered before the judge ruled. Vanessa, he said, had told him the family needed decisive language because I was about to gain access to dangerous wealth. The judge ended the questioning and ordered the transcript forwarded to the state licensing board. Our mother was recalled to the stand. Rachel played the voicemail. Eleanor's own voice filled the courtroom, pleading with me to stop resisting because Vanessa needed temporary access to the trust until the audit passed. When it ended, our mother covered her mouth. Rachel asked what missing money she'd meant. Eleanor said Vanessa had told her the company had a short-term cash problem. Rachel asked whether she knew the affidavit she'd signed claimed I couldn't pay bills or understand financial documents. Eleanor admitted she knew I'd always handle my own expenses, that Vanessa had warned her the business would fail and the bank could take the house without the trust money. Then Rachel asked the question I'd been dreading. Did you believe your daughter's freedom should be traded for your house? Our mother cried again, but this time it didn't help her. She said she thought the guardianship would only last a few months, that I would eventually forgive them. I realized in that moment that my mother hadn't been completely deceived. Vanessa had manipulated her fear, but Eleanor had still chosen comfort over me. Judge Patricia Wells took a brief recess to review everything, then ruled from the bench. The petitioners had failed to prove, by clear and convincing evidence, that I lacked the capacity to manage my estate. In fact, the evidence showed the petition itself had been used as part of an effort to seize control of my trust. She dismissed the guardianship petition, lifted the freeze on distribution, and ordered the trust company to preserve every related record. She referred the suspected forgery, the false affidavit, and the financial transactions to state and federal authorities. Nathan asked permission to withdraw as Vanessa's attorney, citing an ethical conflict. Vanessa stood and shouted that everyone was twisting ordinary business decisions into crimes. The judge ordered her to sit. She didn't, until a deputy stepped closer. Outside the courtroom, 2 federal agents and an assistant U.S. attorney were waiting. The criminal investigation into the Shell vendor network had been developing separately for months. My analysis had helped outside counsel identify the pattern, but Vanessa's forged document and sworn testimony had handed them additional proof of intent. An indictment had been unsealed during the recess. They arrested her on charges connected to wire fraud, falsified records, and unlawful diversion of company funds. Our mother stood against the wall, holding the court papers with both hands. As an agent secured the handcuffs, Vanessa looked at me. You destroyed everything Dad built. I shook my head.
No.
You gambled it away. And then you tried to erase me so no one would see what you'd done. She demanded our mother call someone, fix something, tell the agents they were making a mistake. Eleanor didn't move. Vanessa had spent nearly a year trying to prove I couldn't be trusted with money. By the end of that day, she was the one explaining where every missing dollar had gone. The criminal case took 18 months. Vanessa fought the charges at first, insisting the transfers were business loans and that the trust amendment had been prepared by an unidentified employee. That defense fell apart when prosecutors recovered deleted messages from her personal laptop. In one, she told her assistant that once the court gave her control, she could move the trust money into a family preservation account and repay it before anyone asked questions. In another, she called my anxiety history the cleanest route to control. Facing overwhelming evidence, she took a plea deal, 9 years in federal prison, plus restitution to Bennett Medical Logistics, its minority shareholders, and the investors misled about Silverline Ventures. Her property, investment accounts, and vehicle were seized or sold. She was barred from serving as a financial officer or raising outside capital after her release. For Vanessa, I think the worst part wasn't losing the life she'd built. It was losing control of the story. The public record now showed that the sister she'd called unstable had identified the fraud correctly, while the successful executive had forged documents and weaponized the court system to hide her own losses. Our mother wasn't treated as an innocent bystander either. She'd admitted to signing statements she knew were false and helping pressure me into surrendering control of the trust. Because she cooperated with investigators and hadn't personally profited from the stolen funds, she avoided prison, 6 months of home confinement, 3 years of probation, and a restitution obligation. She had to sell the Ridgewood house. She could no longer afford it. For months afterward, she mailed letters to me through Rachel's office. Some were apologies. Others explained how frightened she'd been of losing the company, the house, the life she knew. I eventually answered one. I told her fear could explain a choice, but it couldn't erase the harm the choice had caused. I wasn't ready to rebuild our relationship, and I wouldn't accept guilt as a substitute for accountability. We now exchange occasional letters, but I keep firm boundaries. Forgiveness, I've learned, doesn't require giving someone immediate access to your life again. Dr. Hale faced a professional investigation. His license was suspended, and he entered a civil settlement tied to the misleading evaluation. Part of that settlement now funds legal services for people whose mental health history has been misused in family financial disputes, which mattered to me because I never wanted my story to suggest that anxiety, therapy, or medication makes someone weak or unreliable. I'd had panic attacks. I needed help. Neither fact made me incapable of managing my own life. When the trust was finally released, the balance was slightly more than $3.2 million, thanks to investment growth. I didn't quit my job, buy a mansion, or spend the money to prove a point. I hired an independent fiduciary advisor with no ties to my family, built a long-term financial plan, paid off my legal costs, and invested the rest conservatively. Then I used part of the inheritance to start something new, a program partnering with community centers and legal aid organizations to help people recognize financial abuse inside families. We teach people how to keep secure copies of wills, trusts, and powers of attorney. We explain why no one should sign a financial document under emotional pressure. We show them how to preserve emails, request independent professional advice, and choose lawyers, doctors, and accountants without hidden conflicts of interest. We also remind people that intuition matters, but serious accusations need to be backed by records, qualified experts, and lawful evidence. The goal was never to make people suspicious of every relative. It was to help them understand that love without accountability can quietly become control. My own work changed too. I stayed a fraud analyst, but I stopped taking every difficult case just to prove I could handle it. I travel more. I spend time with people who respect my boundaries. I've learned to build a family out of trust, not just biology. At the first workshop the program funded, I watched an elderly woman file copies of her estate documents into a secure folder. A young man asked how to protect a parent from a relative pressuring them to change beneficiaries. Another woman quietly admitted her brother had been using her depression diagnosis to control her bank account. That's when I understood. The inheritance was never the most important thing I got back. What I actually recovered was the right to define myself. I think often about how close it came to going the other way. If the trust company hadn't flagged that first forged amendment, if Daniel hadn't kept his own copies of the approval logs, if my mother hadn't left that one unguarded voicemail, the story could have ended very differently. A judge could have signed an order based entirely on a manufactured narrative, and I would have spent years trying to claw back a life that had been legally taken from me on paper. That possibility never fully leaves you. It changes how carefully you document things, how you choose the people you trust, and how seriously you take the small warning signs other people are quick to dismiss. I also think about how ordinary the beginning of it all looked. No one starts a scheme like this with a dramatic announcement. It starts with a question asked over dinner, a document quietly created on a laptop, an invoice for a service that never actually happened. By the time anyone else notices, the pattern is already years old. That's the part one try hardest to explain in the workshops now, that financial abuse inside a family rarely announces itself. It arrives disguised as concern. If there's one thing worth taking from all of this, it's that no one should be allowed to turn a mental health struggle into proof that you don't deserve your own independence. Keep records. Ask questions. Find professionals with no financial stake in the outcome. Don't let shame stop you from asking for help. And remember, standing up for the truth isn't the same as destroying a family. Sometimes the family was already being destroyed by secrecy, greed, and fear. Telling the truth just makes the damage visible. Sometimes I picture that morning in the hallway outside the courtroom. The 15-minute recess, my mother's face losing its color, Vanessa's attorney pulling her aside, and I wonder what would have happened if the sealed file had arrived a day later, or not at all. It's a strange thing to owe your entire future to a single envelope delivered on time. But that's often how these cases turn, not on some dramatic confession, but on one document, one overlooked date, one voicemail nobody thought to delete. What would you have done if the people trying to take your freedom were the same people insisting they only wanted to protect you?